Welcome to this deep dive.
Hi there.
Today we're tackling a profoundly complex and really significant series of events. The fatal shooting of Kumanjayi Walker by Northern Territory police officer Zachary Rolfe in Uwandumu. That was back on November 9, 2019.
And to sort of get a handle on this, we've got quite a range of materials.
We've got news reports, covering Rolfe's acquittal and the later inquest stages.
Right, and importantly, a whole stack of Northern Territory Supreme Court judgments.
Yeah, those really detail the legal arguments, the back and forth.
Exactly. Then there's an investigative report, the Orion one, looking into these perjury allegations within the NT police force connected to the inquest.
And also an account from an investigative program about the shooting itself.
So quite a mix.
Our goal here is really just to navigate through all this information, understand the different layers, the events, the legal fights, the wider context.
And stick purely to the facts presented in these sources without taking sides on any, politically charged stuff.
Exactly. Okay, let's unpack this.
What strikes me straight away is just the sheer breadth of information.
Yeah.
We're not just seeing it from one angle. You've got the immediate news, then the really granular legal detail in the court docs.
And then these later investigations raising, more serious questions.
It really feels like piecing together a puzzle, doesn't it? From different times, different viewpoints.
Absolutely. So let's start at the core event, the shooting. What were the circumstances that led the police to try and arrest Kumanjayi Walker that day?
Okay, so the sources tell us that the attempt on November 9th was because he'd absconded from a curfew. Right. And he'd removed his electronic monitoring device.
And this wasn't the first attempt recently?
No, that's worth noting. There was another attempt to arrest him just a few days before on November 6th.
Okay. And the police operation in Uwandumu on the 9th itself, what did that involve?
Well, they deployed the immediate response team, the IRT.
A specialized unit?
Essentially, yeah. They went to Uwandumu. Sergeant Frost briefed the team.
And their first move?
Their initial action was searching a place called House 577.
But the critical encounter happened elsewhere.
Right. That was later at House 511.
House 511. That's where Rolfe encountered Kumanjayi Walker. Tell us what the sources say happened there.
So the under investigation account in the court documents, they detail that Kumanjayi Walker stabbed Constable Rolfe.
With what?
A pair of scissors. In the left shoulder.
And that stabbing was the immediate trigger for the shots.
That's what the accounts indicate, yes. That act led directly to Rolfe firing his weapon.
And those shots came very quickly.
Extremely quickly. Sources say 3 shots were fired by Rolfe.
Okay, break that down.
The first shot was just after he was stabbed.
Right.
The second one followed about 2.6 seconds later.
And the third?
Almost immediately after the second, just 0.53 seconds later.
And importantly, where was the other officer, Constable Eberl, at that point?
Yeah, that's crucial. At the time of the second and third shots, Constable Eberl was physically engaging with Walker, trying to restrain him.
Okay. We also have some forensic information, don't we, about the impact of those shots?
Yes, the post-mortem examination. It showed the first shot, while serious, wasn't fatal.
So the fatal shot was later.
It was determined to be either the second or the third shot.
And the distance.
Ballistics suggested those second and third shots were fired at extremely close range.
How close?
Within about 5 centimeters of Kumanjayi Walker. Very close indeed.
What about Rolfe's words immediately after? What did he say?
The court documents record his immediate statements. Things like, "It's all good, he was stabbing me, he was stabbing me."
And referencing the scissors.
Yes, it's all good, he's got scissors in his hand, he was stabbing me, he was stabbing you. Suggesting, his perception of an immediate threat to both himself and his partner.
And it's significant, isn't it, that even after being shot, the sources say Walker continued to resist.
That's right. The body-worn camera footage, as described in the judgments, apparently shows Walker continuing to struggle.
Still holding the scissors.
Yes, still had the scissors until they were forcibly taken from him. That detail gives important context for understanding the moments when those second and third shots were fired.
Okay, so that paints a picture of the immediate tragic events. Let's shift now to the legal proceedings that followed. Rolfe faced several charges.
Yes, the primary charge was murder.
And alternatives.
There were 2 alternatives. Reckless or negligent conduct causing death and engaging in a violent act causing death.
And his plea.
He pleaded not guilty to all charges.
And the outcome of the trial.
He was acquitted on all counts by a jury in 2022.
Now, the trial itself wasn't held where it was initially planned, in Alice Springs. It moved to Darwin. Why?
That decision outlined in one of the Supreme Court judgments, Rolfe, no one, I believe, was because of major concerns about pretrial publicity.
Just too much media attention.
Extensive media coverage, yes, and strong community reactions. Public protests, lots of opinions being voiced.
So the worry was jury bias.
The concern was a real risk of potential jury intimidation or bias, essentially making a fair trial seem unlikely in Alice Springs at that time.
Okay. There were also several legal arguments before the main trial even got underway. One involved text messages from Rolfe's phone. What was the argument there?
The Crown wanted to use certain text messages. They argued these messages showed Rolfe had a disregard for police rules, maybe suggesting a tendency towards excessive force.
What was their ultimate point?
They were trying to suggest he might have intended to use his weapon before he even entered House 511.
But the judge disagreed.
Justice Burns, in Rolfe, no aid, found the messages couldn't definitively prove that. He highlighted the difficulty in proving someone's state of mind indirectly.
So the texts weren't seen as strong enough evidence of premeditation, essentially.
Correct. Not conclusive proof of his state of mind at that critical moment, according to the ruling.
Another key pretrial issue was client legal privilege. This came up regarding communications involving the officer's lawyer, right?
Yes, specifically communications between the police officers involved and their lawyer, Mr. Murphy, and also between Mr. Murphy and the police association who had retained him.
And the court's decision.
The court, in Rolfe, no 3, ruled these communications were protected by client legal privilege.
Which means?
Basically, they're confidential, like doctor-patient confidentiality, but for legal advice. It allows clients to speak freely with their lawyer without fear it'll be used against them.
So those communications couldn't be disclosed in court?
Correct. Both the officer lawyer and the lawyer police association, communications related to that legal advice were deemed privileged.
At one stage, the Crown even tried to get the trial put on hold, a stay application. What was that about?
They wanted to pause the trial, yes. This was detailed in Rolfe, Note 6. They were waiting to see if they could get special leave to appeal a decision the full court had made on some legal questions.
But the trial judge said no.
Refused the application, yes.
Yeah.
The court emphasized the need to deal with criminal trials promptly, and also noted that the High Court generally doesn't like granting appeals on these kinds of intermediate rulings in criminal cases before the trial is finished.
So avoiding delays was key.
Exactly. The potential disruption was a major factor. It really highlights, for you listening, the system's focus on moving criminal trials along efficiently.
You mentioned referred questions that went to the full court. That sounds important. What were they digging into?
Hugely important. These were laid out in Rolfe, no 3. They were really about whether Rolfe was acting under the authority of the Police Administration Act, the PAA, specifically when he fired the second and third shots.
Why does that matter so much?
Because Section 148B of that act potentially offers protection from liability, criminal and civil, for police officers acting in good faith while doing their job.
So a specific legal protection for police.
Potentially, yes. The full court also looked at whether other defenses might apply, like self-defense under Section 43BD of the Criminal Code, or whether his conduct was reasonable under Section 208E of the Code.
So it's about where the line is drawn between police duties and individual criminal responsibility.
Precisely. Should an officer in that situation get different legal consideration? And if so, how does that interact with standard criminal defenses? That's what the court was grappling with.
Another point of debate was expert opinion evidence, specifically on police tactics. How did the court handle that?
The court ruled, in Rolfe, not he4, that expert opinions on police tactics were admissible, but with limits.
What kind of limits?
Experts could talk about whether Rolfe's actions aligned with police general orders, training, that sort of thing. The DIMO plus P decision-making model was discussed too.
But they couldn't give the final verdict.
No, they couldn't give an opinion on the ultimate legal question. Was the use of force justified in law? That was for the jury.
So the expert evidence was more about context.
Exactly. To help understand Rolfe's state of mind, his training, and whether his actions were objectively reasonable given that context.
The Crown also wanted to bring in tendency evidence. What's that?
Tendency evidence is basically evidence of someone's past behavior to suggest they have a tendency to act in a certain way.
So bringing up past incidents involving Rolfe.
Yes, the Crown wanted to introduce evidence from 4 prior incidents. They argued it showed Rolfe had a pattern, a tendency towards using excessive force, and then maybe self-justifying his actions afterwards.
But the court didn't allow it.
No. Ruled inadmissible in Rolfe, No. 7. The judge found the circumstances of those past incidents were too different from the Kumanjayi Walker shooting.
So not relevant enough.
The judge decided the probative value, how much it actually proved, the Crown's point in this specific case wasn't strong enough.
And there was a risk of prejudice.
Yes, the potential for unfair prejudice against Rolfe, meaning the jury might be negatively influenced by past events even if not directly relevant, was seen as outweighing any value the evidence might have.
Okay, one last pre-trial point. Seizing Rolfe's mobile phone, was that deemed lawful?
Yes, the court also addressed this in Rolfe, No. 7. The seizure was found to be lawful.
On what grounds?
It was considered incidental to his arrest and a valid search under Section 144 of the Police Administration Act. That section allows police to search someone they've arrested and seize items related to an offense.
Right. So the phone seizure stood. Okay, fast forward past the acquittal. The Kumanjayi Walker inquest resumed in late 2024.
In Alice Springs.
What were some of the key points raised by counsel assisting the coroner in their final submissions? These were widely reported.
They made some very strong allegations during those submissions. Counsel assisting argued that Zachary Rolfe was, quote, dishonest, ego-driven, and held overtly racist attitudes.
Strong words.
Very. They also directed heavy criticism at the NT police force itself.
How so?
Alleging the force missed red flags about Rolfe's prior use of force incidents and pointed to what they thought as significant problems with supervision and training of officers generally.
Suggesting systemic failures.
That was the implication, yes, that these broader issues might have contributed to the tragedy.
But Rolfe's team pushed back on the relevance of the racism claims, didn't they?
They did. His lawyers argued that any alleged racist messages were irrelevant to the inquest's core purpose and had no bearing on the administration of justice in this specific incident.
Okay. Now, separate from the inquest, but related, there was this Orion investigations report. It looked into perjury allegations against police officers involved in the inquest.
That's right. This investigation was sort of kicked off, or at least spurred on, by the NT chief minister publicly challenging people to back up claims of criminal conduct by police officers.
And Orion took up that challenge.
They produced a report focusing on allegations of perjury, which is lying under oath by 5 serving NT police officers during their testimony at the Walker inquest.
What was the core allegation?
The report suggested basically 2 possibilities for these officers. Either they genuinely didn't recognize racist language and behavior within the TRG, the Territory Response Group.
Another specialized unit.
Yes, because maybe that kind of behavior had become so normalized, so entrenched, they just didn't see it as problematic.
Or the alternative.
Or, the report suggested, they might have intentionally given false or misleading evidence, effectively concealing the truth during their testimony.
Did the report give specific examples of this alleged racist culture?
It did. It described what it called entrenched racist language and behavior within the TRG.
Such as?
Specific examples included internal TRG awards,
Right.
certificates with titles like the Nugita Award or Nuguda Award.
What was offensive about them?
The report alleged they contained racist imagery, like historical blackface depictions, and used terms offensively mimicking indigenous language.
And senior officers' testimony about these was questioned.
Yes, the report noted discrepancies or inconsistencies in what senior officers testified about their knowledge, or lack of knowledge, regarding these awards.
The Orion report went further than just the racist content, though, didn't it? It made other serious allegations.
Oh, absolutely. Very serious claims. Allegations about potentially intentionally avoiding witnesses who might have offered contradictory evidence.
And issues with data.
Concerns about possible manipulation or even destruction of data within police computer systems. Metadata analysis apparently suggested some documents might have been deliberately anonymized.
Wow. And collaboration between the officers.
Allegations that the 5 officers under scrutiny might have collaborated when preparing their official statements, perhaps even trying to influence more junior members.
And even interference with internal investigations.
There was an allegation included that the Professional Standards Command, the Police Internal Affairs Unit, might have been told not to investigate the perjury claims specifically.
So what was the report's ultimate recommendation?
It called for a completely new, impartial investigation into these allegations.
And highlighted potential consequences.
Yes, emphasizing the serious legal ramifications of perjury and misleading the court, not just for the individual officers, but potentially also questioning the role of any legal counsel involved.
So as we start to wrap up this deep dive, it's just incredibly clear how many layers there are to this.
Absolutely. You've got the tragic shooting itself, then the intense legal scrutiny of the criminal trial with all those complex arguments we discussed.
Like the PAA defense, the evidence admissibility.
Right. And then you have the ongoing aftermath, the inquest, these very serious allegations of perjury and misconduct swirling around the police force.
If you connect this all up, what really stands out is that stark contrast, isn't it?
Definitely. Between the acquittal in the criminal trial and then these incredibly serious claims raised later in the inquest and documented in the Orion report.
They present really different pictures.
Very different perspectives coming from these different inquiries and sources. And, for you listening, they leave a lot of significant questions still hanging in the air.
So the final thought for you to consider, when you look at all this, the legal interpretations, the testimonies, these allegations of systemic problems that the sources bring forward, what does this whole collection really tell us about the immense challenges of policing, of justice, of accountability, especially in this context?
And maybe, what further questions does this deep dive spark for you personally? Questions about how we weigh evidence, how we determine intent, and what the broader societal ripple effects are from events as critical as these.